name, as Joe said, is Rosana Gutierrez. I am a partner, I'm a corporate lawyer and a partner with the law firm of Rasco Clog Perez and Nieto here in Miami, Florida. So my practice is focused on transactional matters. I work with private equity, venture capital, joint ventures, mergers and acquisitions. And in my work with startups, I generally guide clients through the entire company life cycle. So from establishing the right structure for developing an idea to scaling operations to finally identifying and executing exit strategies. I have a prior life as a non-lawyer, and I actually worked in the public sector for a while. I was served as an advisor to the president of the Government Development Bank for Puerto Rico. And don't blame me for the mess that we're in, unfortunately. That's for other reasons. But during my time there, I was responsible for key government initiatives, and one of those being a $800 million loan guarantee program for small and medium-sized businesses, something that seemed like quite a bit at the time, but of course pales in comparison to what we're talking about today, which is the Coronavirus Aid, Relief, and Economic Security Act. But I say that to make the point that I truly do believe that small and medium-sized businesses are the backbone of the economy. And I think that initiatives such as this, the emergency response program that Generator and Axis have put together, are critical in order to ensure that you're informed and that companies are able to better manage their businesses during these difficult and unprecedented times. So with me, I have Caterina Barquet, who joins me from Barquet Stedge. Caterina is an amazing and highly regarded immigration lawyer in South Florida. She has successfully represented both corporate clients and individuals achieve their immigration goals. She's a member of the American Immigration Lawyers Association and also a very good friend of mine. She will talk to us about some of the immigration-related questions that come up with respect to the CARES Act, particularly important for those of us in the South Florida community. So without further ado, let's go to the presentation. And of course, this wouldn't be a legal presentation without a disclaimer. It is a pretty short one. I've seen lawyers have an entire page full of disclaimers. So what is the CARES Act? So the CARES Act stands for the Coronavirus Aid, Relief, and Economic Security Act. It was passed by Congress and signed into law by President Trump on March 27th of 2020. It stands at over $2 trillion in financial relief. This package is the largest in American history, and its goal is to provide much needed financial relief to Americans that are currently suffering from the public health and economic consequences of the COVID-19. With over 883 pages, our goal is not to cover all of the topics and the financial relief that's available under the CARES Act today, but rather the purpose of this webinar is to highlight the key measures, especially as they relate to small businesses, nonprofits, and solo proprietors. So we will begin with more information regarding to individuals. So there are several individual taxpayer provisions in the CARES Act. One of them is what we've been hearing about a lot in the news, especially lately, is the recovery rebate payments. So what this means is that you will receive a one-time direct deposit payment to eligible Americans of $1,200 per adult, making up to $75,000 a year, or $2,400 to married, $150,000 a year, plus a $500 payment per child under the age of 17 that is a dependent on a Form 1040. Now, the IRS, in terms of calculating your income, the IRS will use 2019 tax returns if these are available, and if not, 2018 tax returns in order to determine how much direct financial aid the individuals will receive. For those who did not have a filing requirement in 2019 or 2018, the IRS will look to other forms, essentially Social Security benefit statements. Do know that advance rebates received will be adjusted up or down when filing your 2020 income tax, okay? There is no action is required for this rebate. It will be, if you have automatic deposit with the IRS, it will be deposited into your bank account. And I believe that payments are starting to happen anytime this week. So the other individual taxpayer provision that we have available is the unemployment assistance. So the CARES Act expanded unemployment benefits for employees who've lost their job due to COVID-19. There are 3 different programs. There's a Pandemic Unemployment Assistance Program, Pandemic Emergency Unemployment Compensation Program, and also the Pandemic Emergency Unemployment Compensation Program. I've listed a website on the slide. Hopefully you can see that and read that okay. You can go to that website for more information. Florida is particular in this respect in that they actually allow you to file a claim for unemployment in multiple ways. You can do a paper claim, you can call in a claim at that number, that 800 number that's listed there, and you can also file an unemployment claim online. The other topic that we're talking about here is hardship withdrawals and loans from 401k plans and IRAs. So typically when you do a withdrawal from an IRA or a 401k plan, you have to pay a 10% penalty plus, of course, income taxes on the amount that's withdrawn. During the year 2020, if you make a distribution, that distribution will be penalty free for those under 59.5. Now, do bear in mind that you will pay taxes on the amount distributed, but even that is the CARES Act allows for the income recognition of those taxes to be over a 3-year period starting in 2020. So you don't have to pay taxes all at once, but rather it's spread over a 3-year period if this is something that would be of interest to you. You also, the taxpayer, you also have the choice to avoid any income recognition if you repay the entire distribution amount within the 3-year period. So if for whatever reason you're going, through a hardship now and you want to make a distribution from your IRA or from your 401k plan and you repay that distribution within the next 3 years, then you don't pay penalties and you wouldn't pay income taxes on it. So a couple more things on individual taxpayer provisions. One, this actually, I wanted to point this out because it also relates specifically to nonprofits as something that you can make sure that your donors are aware of, which is charitable contributions. So the limitation on charitable contributions that you can deduct from your income taxes has been increased. So for taxpayers that don't itemize, you can deduct up to $300 for qualified cash charitable contributions. For taxpayers who do itemize, the limitations were increased. So for individuals, it's generally capped to 50% of adjusted gross income, and that cap has been suspended for year 2020. For corporations, the 10% limitation has been increased to 25% of taxable income. Lastly, let's talk about employer repayment of student loan debt. For year 2020, employers can pay up to $5,250 of an employee's student loan without such payment being treated as income for the employee. Now, why do we mention this? Because currently there is $1.56 trillion of student loan debt in the United States. That's a pretty significant amount. So employers that want to get creative can include these repayments as part of the overall compensation of employees. And for year 2020, that would mean that it's not, that repayment is not treated as income for the employee. Otherwise, the employee, if this is done any other year, the employee would have to recognize that amount as income on its income on its taxes and pay income taxes on such amount. Now, no application would be required for this. It would just show in your Form W-2 that these payments are excluded from taxable income. All right, so now we're getting into the meats of the CARES Act. So the CARES Act does two things in terms of small business loans, right? So we have the Paycheck Protection Program and the Economic Injury Disaster Loan Program. And we're gonna talk about both today. And we'll also highlight some of the difference between one and the other and why one may be more beneficial for your business. So what is the Paycheck Protection Program? It provides forgivable loans to small businesses for payroll purposes, and of course with the goal of encouraging companies to retain employees. The forgivable loans are the amount of the forgivable loans is equal to 2.5 times your average monthly payroll cost to a maximum of $10 million. Now, what are payroll costs? Payroll costs include salary, wages, commissions, or tips. Now, this amount is capped at $100,000 on an annualized basis for each employee, okay? And it's important to also note that this is only for employees whose principal place of residence is the United States. So, for example, if you have employees in Colombia that are doing your intellectual or your IT, you cannot factor in those employees when calculating payroll costs for purposes of the Paycheck Protection Program. Okay, what's also included in payroll costs is employee benefits, including costs for vacation, parental, family, medical, or sick leave, also separation or dismissal payments, and payments required for group healthcare benefits, including insurance premiums, as well as payments of any retirement benefits. Okay, who is eligible for these loans? So small businesses that have been in operation on February 15th, 2020 with fewer than 500 employees. It includes qualifying nonprofits, and eligible nonprofits are 501c3s and 501c19 veterans organizations. Okay. Loan terms. So the loan term is, so what actually the law allows for a maximum of 4 years, but the rule actually capped it at 2 years. So it's a 1% fixed interest rate for a period of 2 years. There's no prepayment penalty, and the loan payments will be deferred for the first 6 months. So you don't have to make any payments for the first 6 months, okay? Now, why is this program so popular and why have you been hearing so much about it? Because these loans actually can turn into grants. That means you don't have to repay them. Of course, there are rules attached to this. So how are loans forgiven? If you use the loan proceeds for payroll cost, you can also use them for mortgage interest, for rent, and for utility payments over the 8-week period after the date of disbursement. Your loans will be forgiven. Now, it is important to clarify, that you cannot use more than 25% of the loan amount for non-payroll costs, okay? So yes, you can use it for mortgage interest, rent, and utilities, but that can't be more than 25% of the total amount, okay? So 75% for straight up payroll costs, compensation, whatnot, 25% for rent, utilities, mortgage interest, and the other. If you've done that, then you can apply for forgiveness and potentially have this loan forgiven, which means you don't have to repay it. Again, it turns into a grant. So how can you apply? You can apply through any existing SBA lender. And of course, as I'm sure you've been hearing, maybe from even your own banks, there are a number of new banks that are participating in this program that don't necessarily have to be SBA qualified as SBA lenders. I would suggest that you reach out to your bank. It will facilitate the paperwork as well, and see if they're participating in the program. And if they are, that's probably your best bet in order to start the process. You can only have one up, or you're supposed to only have one application out at a time. But of course, if you're denied, there's nothing that prevents you from, applying with a different bank. Just to give you an idea of how popular this program has been, as of yesterday, I believe that there's been more than $215 billion in loans processed. So yes, it is first come, first serve. And if you're interested and if you believe that you qualify, you should apply as soon as possible, because there are limited funds, and everybody, the general consensus is that funds will run out. And at this point, yes, it's been discussed that there may be additional funds allocated to this program, but that hasn't happened yet. So the sooner that you get started, the better. And in terms of timing, small businesses and sole proprietorships were able to start applying back in April 3rd, independent contractors and self-employed individuals on April 10th. So at this point, everybody that qualifies is able to apply. In terms of the other point that I wanted to mention with respect to Paycheck Protection Program is, because there's been a lot of confusion about this, so I just wanted to clarify. Payments that are made to independent contractors do not qualify for purposes of calculating your payroll cost, because these independent contractors can apply on their own. Therefore, the thought process is, they can apply for their own loans, and that takes care of that. So if you're a business, as a lot of businesses here in Miami are, or in Florida in general, if you're a business that have a limited number of employees, but actually do a lot of work with independent contractors, meaning that you issue 1099s, you cannot count those 1099s for purposes of calculating your payroll cost. In terms of, and I think there was a question about this yesterday, so I'll just mention it briefly, who's ineligible, even though you meet all of the criteria that we just talked about. Companies that are engaged in illegal activities, that was kind of obvious. Household employers, so even if you have your nannies or your housekeepers as employees, you're not eligible for this program. Also, if an equity owner of the applicant is that has more than 20% equity is incarcerated, on probation, or on parole, you're ineligible. And finally, if you or if any of the business owners have ever obtained a direct or guaranteed loan from the SBA that is currently delinquent or that has defaulted within the last 7 years. So even if you meet all the other criteria, if you fall in any one of those 4 categories, you would be ineligible for this program. So now let's talk a little bit about the second program under the CARES Act, which is economic injury disaster loans. So this is actually not a new program per se. This is an existing program that's offered by the Small Business Administration. The economic injury disaster loans are low interest loans that are provided through the SBA disaster loan program to help businesses and homeowners recover from declared disasters. Currently, the EIDLs, as they're also known, they provide vital economic support to small businesses to help overcome the temporary loss of revenue that they may be experiencing as a result of the COVID-19 pandemic. What does the CARES Act do? It actually expands eligibility for access to these loans so that it includes not only businesses with fewer than 500 employees, but also sole proprietors, and it also provides upfront grants. So typically the economic injury disaster loan program is just that. It's a loan, it's not a grant. But through the CARES Act, they're able to provide an advance grant of up to $10,000. Okay? Now, as I say, you can request a loan advance of up to $10,000, which the SBA may distribute within 3 days. I've heard that this may or may not be happening, the 3 days. The SBA is currently, as you can imagine, overwhelmed with everything that's going on at the same time. But that is the intent, and I think that as time goes by, that will happen more and more. You can use that advance for any purpose that's allowed under the Small Business Act, and this is actually pretty broad. The use of funds is much broader than under the Paycheck Protection Program. You can use it for working capital. So any obligations that the business has that you haven't been able to meet because of the situation that we're all in, you can use these funds for that. Okay. The other thing that the CARES Act does for the economic injury disaster loans is that it waives the requirement of personal guarantees for certain loans. And although you do have to be able to show that you were in business on January 31st, 2020. Okay. The other thing that the CARES Act does is that it waives the credit elsewhere test that the SBA generally employs. So that means that typically the SBA will want a business to show that they haven't been able to obtain financing in other places before the SBA finally issues a loan or a guarantee. So that test is actually waived for this program. I list there the website where you can apply for the EIDL. You apply directly through the SBA, and there's also a phone number that you can reach and an email. In terms of eligibility, much broader than the Paycheck Protection Program. So it also includes any private nonprofit under 501c D or E of the IRS code, but it explicitly excludes entities that are nonprofit or organizations that are primarily engaged in lobbying or political activities. These cannot participate in the EIDL program. In terms of the loan terms per se, they have a fixed interest rate, 3.75 for small businesses. For nonprofits, it's 2.75. And the term per se could be up to a maximum of 30 years. But terms are determined on a case-by-case basis. Okay, so when we look at the economic injury disaster loan program versus the Paycheck Protection Program, what is the main difference? So like I said before, the Paycheck Protection Program, the main attraction is that these are loans that can be converted into grants if you meet the requirements. The economic injury disaster loans are loans. These are not converted and cannot be converted into grants. However, you do have that up to $10,000 loan advance that is a grant that does not have to be paid back if you receive it. Okay, but it's just the $10,000 versus the entire principal loan amount under a Paycheck Protection Program if you qualify for that. Other difference between the Paycheck Protection Program and the Economic Injury Disaster Loan Program is the issuing entity, right? So like I mentioned, with the Economic Injury Disaster Loans, you actually go straight to the SBA, and that's where you file your application, and the SBA is your lender. With the Paycheck Protection Program, you have to go through a traditional bank. So either an SBA approved lender or one of the many new lenders that are now joining the SBA in this effort. The Paycheck Protection Program also has more restrictions on what you can use the money for. So yes, you can qualify for forgiveness, but in order for that to happen, like I said before, at least 75% of the loan proceeds have to be spent on payroll, okay? The Paycheck Protection Loan programs can also be much larger than the economic injury disaster loans. So the limit the maximum amount under the Paycheck Protection Program is, $10 million versus the EIDL, which is just $2 million. Can you get both? Yes, except you cannot use them for the same purpose, right? You can also, and this, we get a little more technical here, but you could also get creative and you may be able to roll an economic injury disaster loan into a paycheck protection loan, potentially qualifying for forgiveness and decreasing the interest rate as well. But this is something that you have to look at more carefully and see if you qualify for both. No? So just a few other opportunities and under the CARES Act, and these are more technical and definitely something that I would encourage you to talk to your accountant about if you think they apply to your business, but I do want to highlight them because they are important and could be significant in terms of financial relief. So you have the Employee Retention Tax Credit. The CARES Act provides for a refundable payroll tax credit of up to $5,000 per employee for companies that were where operations were fully or partially suspended due to the coronavirus pandemic, or whose gross receipts declined by more than 50% when compared to the same quarter in the prior year. Now, keep in mind, if you actually qualify and receive a loan under the Paycheck Protection Loan Program, you cannot also claim the Employee Retention Tax Credit. So these two are mutually exclusive. There's also the unemployment benefits that we talked about earlier. With respect to nonprofits in particular, there's a specific section that allows nonprofits to be reimbursed for half of the costs incurred through the end of 2020 to pay for unemployment benefits. So I would definitely look into that if this is something that's applicable to you. And then lastly, there's a deferral of payroll taxes. This allows employers to defer payment of the employer portion of Social Security taxes, which is 6.2%. You do have to repay them, it's just deferred, and you can pay them over the next 2 years, with half by the end of year 2021 and the other half by the end of year 2022. Again, if you have a loan under the Paycheck Protection Program that is forgiven, then payroll taxes may not be deferred, okay? And this applies to all companies, not just nonprofits. So to recap and kind of hone it in, next steps in terms of what you should be doing if you're a nonprofit, definitely look into the Paycheck Protection Program, the economic injury disaster loans, and a loan advance. I would also be talking to your accountant about employee retention credits, deferral of payroll taxes and unemployment benefits. And in terms of, your reach out to your donors, charitable contribution limitations increase might be an attractive topic. If you're a sole proprietor or an independent contractor, Paycheck Protection Program has been very popular. The economic injury disaster loan and advances, again, unemployment benefits, and of course the recovery rebates, because these are for individuals. So like I said, if you qualified for the Paycheck Protection Program, you wouldn't qualify for the employee retention credit or the payroll tax deferral. So that's where no double dipping is allowed. But like I said before, and it's important to say it again, you can apply for and receive both a Paycheck Protection Program and economic injury disaster loan, but the funds cannot be used for the same purpose, but you can receive both. Employers who apply for the economic injury disaster loans can also receive a $10,000 grant advance. This amount would be deducted from the total amount of the Paycheck Protection loan that you would be eligible for. So just bear that in mind. And that is it for me. I'm happy to take any questions that you may have, but we will first turn it over to Katerina. Is that right?
Yeah, so I was thinking we could pause for a couple of questions before these kind of like lose top of mind. So the first question is recovery rebate payments. Does that apply to legal permanent residents under a green card?
So I think that's Katarina's.
That's going to come up in the next topic. So I think maybe we can go over my presentation.
Sounds good.
Which is pretty quick, and then that we can do all questions together.
Perfect.
All right, so Rosanna already did the introduction, so I won't go over, what I do. I specialize in immigration law. I've worked with many startups, corporations, individuals, you name it. So I'll just dig right into it. There's been a couple of questions of, such as the one that was just posed as to who can take advantage of these different programs. So here I go over the basics. First, can foreign nationals take paid leave during this time? Anyone with work authorization, with valid work authorization currently is eligible to take paid leave as long as you comply with all federal and state laws. So I would first check with your local attorney and your local state employment attorney to see whether there's any issues there. But from an immigration perspective, it's allowed. The second big one is, are foreign nationals eligible for unemployment insurance? This is a little bit tricky because each state has different requirements as to who's eligible and who's not. So first you have to consult with, each state agency to see what's allowed. And then comes the Immigration Reform and Control Act, which states that, for example, states are required to utilize what's called the Electronic Systematic Alien Verification for Entitlements, the SAFE program, to verify your immigration and citizenship status. Those who are eligible under these guidelines could also be eligible for the CARES Act emergency increase of $600 per week. Regarding the public charge analysis, a lot of people have asked me, will this impact my ability to extend non-immigrant status or adjust to permanent residence, since there's a big issue with anybody that's considered a public charge is getting denied their green cards. However, unemployment insurance benefits are not considered unearned benefits, meaning that they do not impact your ability to do any of these things, and you're able to take unemployment insurance benefits without it falling under the public charge analysis. This public charge rule exempts disaster relief and applies to individuals and not business entities. So that's why it's not considered a public charge, because under disaster relief programs, there's an exemption for all disaster relief programs. Regarding green card holders, the public charge rule applies to those in the process of applying for green cards, not those who already have green cards. So if you already have a green card, you shouldn't even have to worry about this issue. However, this is the big issue that comes up, which I just had somebody who lost their job ask me whether they could take advantage of it, is if a foreign national has lost their job, then the foreign national is technically not able and available to work and therefore will not qualify for unemployment insurance benefits. So to summarize, if you currently have valid work authorization under an E2 visa, an H1B visa, an L1 visa, and you're currently employed, you will be eligible. However, if you're laid off from that employment, the second you're laid off, you're no longer eligible. So that's basically the takeaway from this. And then we can go to the next slide. Oh, we skipped some stuff there. Wait, there's another slide. I think we skipped it. Yeah, I think go up. Okay, there. So are foreign-owned businesses or foreign nationals eligible to apply for an SBA Economic Injury Disaster Loan or Paycheck Protection Program? The application does not expressly require that you must be a U.S. citizen or a green card holder to be eligible. Therefore, business owners on visas or green card can apply for this loan. So I would immediately, if you're able to take advantage, as Rosanna mentioned, there's a cap. We don't know if it's going to be replenished, so go ahead and apply now before it's too late. are foreign nationals eligible for a recovery rebate. The only individuals eligible for this payment are those with valid social security numbers and those who qualify as resident aliens as defined by the IRS. Under the IRS, non-US citizens are considered non-resident aliens unless they meet the green card test or the substantial presence test. So again, anybody can apply for the Paycheck Protection Program or an SBA Economic Injury Disaster Loan. However, for the recovery rebate, it's much more complex. If you don't have a valid social security number and you qualify as a resident alien, you will not qualify for it. Furthermore, the IRS is not an immigration regulation so much as the IRS exempts certain types of non-immigrant visa statuses, such as the F1 student status, from the physical presence calculation, meaning that F1 students are likely not eligible for recovery rebates. However, H1B, L1, E2 professionals will be eligible as long as they live in the US, meet that substantial presence test, or are green card holders. But the F1 students will not be able to apply for recovery rebates. Now, another question I've gotten is, my employer is reducing my salary, what about my visa status? So this really only applies to those who are on visa statuses that require labor certification confirmations of the wage, such as the H-1B or certain other processes. For example, let's say you're on H-1B and you have, your wage was qualified at $50,000 a year. The prevailing wage is $50,000 a year. Then the USCIS has found that you cannot go below the prevailing wage. So no, if your salary was $50,000 a year and the minimum prevailing wage that was approved was $50,000, then they could not reduce your salary without impacting your visa status. They would need to do an amendment of the visa petition requesting a new application for the new wage. However, on the other hand, let's say that you were being paid $80,000 a year and the minimum prevailing wage approved was $50,000, then technically your employer can reduce your salary to $50,000 without a need to do a new amendment and without impacting your visa status. So I put here the quote from USCIS that confirms the ability to reduce salary without impacting an H-1B petition. But this is very specific, but I wanted to make a note of it because there has been a lot of questions or emails to me about what, my salary has been reduced. Is it going to impact my visa status? What do I do? So overall, these are the main issues that have come across my desk and as well as Rosanna from the immigration perspective. So that's it on my end. So I guess if we can start with the questions now. I think the first question about the green card holders was answered, but I'll let Joe and Rosanna take over.
Yeah, the first one from Tanisha was, with the Paycheck Protection Program, it can turn into a grant as long as you use funding approximately over 8-week period. Are you resubmitting information to banks, and how will they know? I think this is a compliance question, around how will you know that you've complied with the terms of the loan in order to recognize the forgiveness?
Right. And I think the answer to that is that it's actually, it will probably depend on your bank and your lender and their requirements. I know that for purposes of obtaining the loan in the first place, different banks are requesting different things. Just, from firsthand experience, I can tell you that much. But what we do know is that you do have to be able to show that during those 8 weeks, you use the funds for the permitted purposes. So you have to be able to demonstrate that you paid at least 75% of the funds were used for payment of payroll costs, right? So compensation and whatnot. And the other 25% could be used for rent, utility, and those things. So you would have to be able to show that that's what the funds were used for.
Awesome, thanks. The next question is, can you apply for an EIDL grant and for unemployment if you are self-employed?
Sorry. Okay, there. Let's see it. So you can apply for an economic injury disaster loan grant. And actually, I may just tie this into the one below because I think they're a little related. So on the SBA website, on the Small Business Administration website, they have the application for the EIDL loan. And in that application itself, you apply for the grant. So for the advance, which is a grant. So you don't apply for it separately. That addresses the other question. Now, I'm not sure if you would qualify for unemployment as well. I would have to look into that specific question.
Oh, thanks.
Sure.
What if you are employed, or what if you are employed and are a sole proprietor? What do you apply for? So I think this is like if you have two different streams of income here.
Right. Well, I mean, bear in mind that when you're applying, I'm thinking maybe the question is, do you apply for either one of the loan programs? So do bear in mind that when you're completing an application for either one of these loan programs, there are certain certifications that you have to make, right? And for example, with the Paycheck Protection Program, you have to be able to certify that the current economic uncertainty makes the loan necessary to support the ongoing operations of the organization, right? Now, if you're also employed and you're receiving income, I don't know how, if you're necessarily going to be able to make that certification. So I think it's something that will have to be evaluated on a case-by-case basis, depending on the circumstances. But that's one thing to keep in mind, is that, of course, the purpose of these loans is to help businesses that actually need the funds. So if you're receiving funds from somewhere else, from an employer, you may not necessarily qualify. So it would have to be evaluated on a case-by-case basis. So.
All right, thanks. And then the last question, this is probably for Katerina. If you are sponsored by your employer and they furlough you, will you lose your visa? And what is the time frame to leave the country?
Yeah, so technically, if you lose your job, let's say your employer lays you off today, technically the moment that you're laid off, your visa is no longer valid, and you're no longer in status, because the whole point of having that visa is that you're employed. However, immigration understands that it's not reasonable to lose your job today and leave tomorrow. So usually I would say a reasonable time frame to leave the country would be 1 to 2 weeks after you get all your affairs in order. If it has to be longer, as long as you're able to support a reason why you had to stay longer, such as you had to take care of rent payments, you had to find a flight, and you couldn't find a flight on time. All those things matter. So I would just keep a record of why you left on a certain date. Again, there's no statutory bar to entering the country. There's a 3-year bar if you stay 6 months or longer in the U.S. without status. If you stay less than 6 months, there's legally no statutory bar to coming back to the U.S., but it's not recommended. I would say as soon as you get your affairs in order, whether it's 1 to 3 weeks, you should be fine.
Great, thanks. I can share my screen for some of the closing slides.
Cool. We want to thank you for coming on and doing this presentation. We will follow up with you. As anybody wants to reach out for additional questions, feel free to reach out directly or send a note to us. And we will follow up with the speakers and get you the information. Tomorrow we do have another webinar. We'll be sending that information with Patty, along with links to sign up for the one-on-ones with our team. And again, we will be posting this information on our research page. So we hope you found this valuable. We really appreciate everyone's time and engagement. And again, if you have any additional follow-up, please do reach out and we'll try to wrap it up. But thank you to our speakers. It was a wonderful presentation. It was really well appreciated and engaged. And we look forward to talking to you all tomorrow. Thanks, everybody.
Thank you.